Hi, I'm Anna Edmonds from the F-Suite, Columbia's only business magazine for female entrepreneurs and small business owners. And I'm here with Earl Gregorich, who's a consultant with the South Carolina Small Business Development Center up in Greenville, and my colleague Doug Lineberry, who is a partner in the law firm of Burr and Forman up in Greenville, and he specializes in intellectual property, which just happens to be perfect for the topic that we're going to discuss today. Doug, what is intellectual property?
Sure. You know, Anna, you're asking that as almost as like there's a simple answer. There are four big categories of it and all kinds of sundry various subcategories. We're looking first at patents. Our next option is a trademark. Third option is a copyright. And our fourth option, which is almost always forgotten, and considering its name that's kind of funny, is a trade secret. To go over these just in a nutshell, patents protect inventions. If you have something that can be reverse engineered, you want to get a patent on it. If you're going to sell it on the market and someone can take it apart and figure out how to make it, look at a patent. That is the best way to protect that innovation. A trademark protects what you've used to basically make your company and its services known to others. You want that symbol like McDonald's golden arches, the Coca-Cola swoosh, the Nike swoosh. When people see that, you want them to refer back to your company and be like, that's Anna and F-Suite. They do really good articles. Those are really insightful. They've been a big help to my female-owned business or just my business in general. I know F-Suite. They're good. I like them. And so a trademark is essentially how consumers recognize you, either by the goods you produce or the services you provide. Now, our third version is a copyright. A copyright protects artistic creations. And that causes a lot of people's eyes to glaze over. But what it really means is if it's an original work, and it can be a statue, it can be computer code, it can be a book, it can be a movie, or it can be a sound recording. Those are the big fields, but it protects a lot of other things too. But if it's an original work created by someone, that's copyright's domain. Now, the third one we have is a trade secret. A trade secret is just that. It's the shh. We don't want to tell people what it is. Think pricing lists, expansion plans, product development that we're not ready for people to know about. Those are all trade secret categories, things that bring a value to our business because they're not known to our competitors. You know, our pricing, where we get our raw sources from, you know, who our best customers are. You know, maybe we have some novel way of delivering a product or a service that somebody else doesn't and they can't determine it. Those are your trade secrets. And I'll posit this. When you look at the world of intellectual property in those four areas, they're not distinct slices of a pie. They meld into each other. A patented product may have a trademark. A patented product may have copyright associated with it. A patented product may be used with a trade secret. So you see this sort of amorphous Venn diagram to where things overlap, where things flush back and forward. And so we want people to understand that even though you might have one of these, there's a really good chance that you may have some of the other three as well. Now, a trade secret and a patent are juxtaposed in a couple things. To get a patent application, you have to literally tell how to make it, how to function it, and all the aspects about it. Whereas a trade secret, we don't want to tell those things because guess what? If we do, we probably give our competitors a foot up. You know, we allow them to have insight into how we do business, and it also undercuts our advantage that we have over them. Trademark and copyright, think of a logo. You can trademark a logo used in business. You can get a copyright on that same logo. So our forms of intellectual property, consider them all because a small business entrepreneur needs to at least have done the checklist of, hey, do I have a patent? If not, do I have a trademark? Almost certainly. Is there a copyright associated with that? Almost certainly, especially if a third party created that logo for you. And do I have trade secrets? Absolutely, you do. Promise you. So as a small business, we need to do that checklist. Patent, trademark, copyright, trade secret, and understand how those impact us. Because trade secrets, we don't want on the company website. But trademarks, we want all over the company website. And so, Anna, that really is sort of it in a nutshell, the four big areas of intellectual property.
So just to clarify, is, for example, the recipe for Kentucky Fried Chicken, is that a trade secret?
Yes, it is. Okay. Those 12 secret herbs and spices are not on the Kentucky Fried Chicken website. They're not in the commercials, and they're never divulged to people. Same for the Coca-Cola secret recipe. They go to such great lengths that only two people in the company know it at the same time. They don't travel together in case something happens.
Right.
Yeah, it's kind of funny. A lot of small business owners don't realize that it's kind of an oxymoron. You want to protect your intellectual property, but the first thing that happens is it goes into public domain, unless it's a trade secret, right?
Absolutely. I mean, Earl, that's a brilliant point, because if you've got the ability to patent something and you're out there selling it to make money on it first, you've already lost your foreign rights. You can't protect that device in Japan. You can't protect it in Europe. You can't protect it outside the US. But even in the US, you've only got 1 year. Let's say we make a sale today, November 30th, 2020. If we make a sale today, or even we just offer it for sale, we put it on the website, here it is, Cyber Monday, buy this from Anna. Guys, we have 1 year to protect that in the US, and it's too late other places. And that is a hard thing about my practice, is people will come in and tell me how they started making money on something. It's really to the point where they need to protect it. But sadly, there are a lot of times when I have to look at it and say, guys, you can't protect this iteration. It was on sale more than a year before you came to me. And so that, guys, is one of the things that small businesses have to understand, is that this isn't some big esoteric thing that should only be considered for like vast companies like Microsoft and Google. Every small business has at least one, if not all, of the 4 areas of intellectual property.
That's a lot of information. Okay, so what is copyright infringement, or any kind of infringement on any of these 4 areas? What does that actually mean?
Sure. Infringement means that you've gone out and are using something that's not yours. You know, if it's a patent, guess what? The claims of a patent say, hey, this is my device. And Anna, if you or I or Earl or somebody else makes one that encompasses those, and we sell it, we try to import something that does that, that's patent infringement. Trademark infringement. Anna, your F-Suite, you got your idea by looking at you looked at some massive magazine out of Colorado that's huge out in the West, not so big on the East. You made your logo look just like theirs. That's trademark infringement. Copyright infringement, guess what? We saw somebody's computer code and we were like, you know what? I'm going to change just a little of that, and I'm going to make my computer code do the same thing, but I'm going to change some of it. That is copyright infringement. Also the same as if, say, we had a painting, or plagiarism is also infringement. You know, if Earl has a novel and I take and start copying sections of it, that is plagiarism, but it's also copyright infringement if Earl still owns the copyright. Trade secrets, infringement of those is a little bit touchy because we don't want people to know about those. If somebody separately creates it, you know, that's one of the fears of a trade secret, is that, hey, people do think alike. You may have parallel development between 2 parties. So infringement in that case has to be viewed from, did they get exposed to it and were able to take it and run with it? Because if they weren't exposed to it but came up with it on their own, that's one of the fears of having a trade secret as your sole type of protection.
Okay. So in everyday life, in general, in my case in particular, I know somebody was using photos of mine. And so, Earl, I'll let you talk about this. I don't want to sit here and complain and have like people wondering, oh, was it me? Was it me? Because I'm not upset at anybody. But when you see something like that happening, Earl, what are the steps that you can take before you have to call someone like Doug?
Yeah. So, you know, copying is supposedly flattery, right? Is what they say. But the fact of the matter is, copying can also hurt your brand and hurt the value of what you have in the marketplace. So, you know, first thing you want to do is reach out to the offender and just say, hey, look, I noticed that you've got this going on. Just so you know, we've got this protected. We'd like you to stop doing what you're doing. And you can just simply talk to them if you want, or you can formalize that in a cease and desist letter if you choose. But it's always good to try and keep it out of the courts if at all possible. You know, even the lawyers will tell you that, and I would agree with that, I'm sure. So just a casual conversation with the offender to try and head that off at the pass before anybody has to start throwing big money and getting lawyers involved at it.
Right. So, Doug, I want to talk about the fact, because I run a magazine, I have people contributing articles to me. So I have to make sure that what the content that they're contributing is actually their material, and they're not copying and pasting, whether it's a photo or written content or whatever. Because if it turns out that there is a copyright or trademark, whatever it is out there, they look at me as the owner of the magazine as the deep pocket. It doesn't matter if my pocket's only a centimeter deep. They think I'm the deep pocket. So I'm gonna throw that at you and let you explain what I'm talking about and how dangerous it can be.
Absolutely. And Anna, that's one thing a lot of people don't appreciate it. If you have a website and you go somewhere else and clip a paragraph, or you clip a photo, or if you clip a sound bite,
Right.
you may be committing copyright infringement. You as a magazine owner, publisher, editor, you appreciate this on a different level, because guess what? The buck stops with you, as they say.
Yeah.
You know, if that happens, let's say that one of Earl's pictures lands in your magazine, Earl's not going to go to whoever's byline it is. He's coming to Anna Edmonds and saying, hey, that is my picture. And I've had clients stumble into this exact same thing. That is my picture. Why is it in your magazine? This happens a lot. One thing you need to do, Anna, is to make certain that your contributors are doing two things. That we have a signed, literally signed agreement with them that I created this. Also, there needs to be what is called an indemnification clause, meaning that if Earl comes out of the woodwork, or Doug or somebody else, and says, Anna, what's this doing in here? It needs to be, the hook needs to be put back to that person. Now, one thing to worry about though, Anna, is like you were talking about deep pockets. You are helping with this. When you publish it, you know, that is an infringement itself, even if it's sent from somebody else. So are you free and clear just because we have an agreement with somebody else? We're not. But what we want to do is to put that onus back on them. Another thing that I will tell people to look at is insurance. I know it seems weird that we would bring that into an intellectual property discussion, but there are insurance coverages for this, especially as a magazine. There are things that you want to look at that will protect you from this, to say, hey, I didn't know. And then this poor broke pauper of a story writer came to me, used somebody's photo, you know, some famous photographer, and that person can typically sell those photos for $25,000, $30,000 a piece. Here I am in the F suite with this particular photo in it. Guess what? Those numbers, not just from a legal sense, but also remember that copyright is strict infringement, that you are liable. And it's not a matter of, I didn't mean to, and I'm so sorry about it. If you did it, you're liable for the profits that you made using that particular work. I'm sorry is great to say, but it won't erase any of it. But having insurance or having an indemnification clause from whomever you're dealing with are really good ways to start the protective process.
I think it's really important to point out that even if you're accused of infringement and you're not guilty and you know you're not, and I'm going to bring an insurance agent in to talk about this in a future issue, just defending against, just to hire someone like you to defend, because the person making allegations is going to keep me in court. You're going to go through discovery. There's going to be all sorts of crap going on, pardon my language. And I don't know how many hundreds of dollars you charge, but I don't know any cheap lawyers out there. And if you don't have insurance to cover the cost of those legal fees, even if you've done nothing wrong, you're going to lose your business.
I agree. And typically, Anna, you know, we won't fearmonger too much. I think there's too much in 2020. But one thing is to understand is a lot of these are handled behind the scenes. But even then, they're not cheap. And it really depends on the third party, because, you know, if you've got Earl coming at this from a business professional who's like, hey, you know, I need you to pull that down, need you to undo what you've done, that's one situation. But if you have somebody who has emotional content, who feels that you've insulted him or her, or that you've somehow, you know, done something that they consider to be personally reprehensible, that can make things so much more difficult. And so we need to understand that even if there's not a court case here, that yeah, at my $400 an hour, arguing with somebody becomes really expensive.
Yes.
And so we want to take pre-measures on this. We want to say, hey, we don't want to infringe. Let's put in some safety nets that do the best we can to prevent that. Insurance, you know, indemnification, agreements that, hey, this is mine, I didn't take it from anybody else. And also for any original created works, let's keep a file. And let's say I went out and took this photo at wherever you were at, you know, the Columbia Zoo. I took this photo of the monkeys in the tree that day. That is now my main thing for my business, but it's my photo because I took it. I can show you that I have it in this file. That sort of backup, y'all, is huge, but so many people don't think about it. You know, when you ask a lot of people where photos come from their website, you know, they may say clip art, and that's okay. Make certain that you're using it per that agreement, because if you start to go outside of that agreement, that can be infringement too. But for those original works that you've created, whether you've designed your own logo or you've taken pictures or you've done text, you need to be able to say, hey, November 20th, 2020 is when I created this, or November 30th, or December 1st, whenever it might have been, and have documentation to prove that.
Yeah, you know, a lot of small businesses can avoid these situations. You know, I tell clients, you know, if you don't want to be put in the position of having to answer the question, don't make a reason for somebody to ask it.
Yep.
So if you go out and you take your own pictures, if you create your own art, if you do your own stuff and you don't go out and do these copy and paste, if you don't use stock art websites and things like that, you don't set yourself up for these issues. Can it still happen? Sure. You might have taken a photo that's very similar to somebody else's, but at least like Doug just said, you've got records, you've got timelines, you've got things that you can point to prove it's yours. If you don't do those things, then you run the risk. If you do things that are original, things that you can put a track record to, you don't have to worry about getting that question in the first place. So always try to do that.
Well, that leads into my last question, Earl, and this is very personal between you and me. I actually have on my website and in a couple issues of my magazine, articles that you wrote, that you published. So why is that not considered copyright infringement that I published them? What did I do to make sure that that didn't happen? I'll let you explain that.
Well, one, you trust me as a source, right? You ask a lot of people to write material for you.
Yes.
You wouldn't ask somebody to write material that you might think, yeah, they're just going to go copy, paste, tweak a few words and throw that in front of me. So that's one thing. You're working with people that you trust are going to do the right thing. Two, you've seen a lot of my material out there. You can tell probably by reading something or viewing a video that, yep, that's Earl. You know, so it's pretty obvious to you that that material is original material. And, you know, you and I have actually discussed, you know, I've got material out there and I'll say, hey, you want to use this, or you want to use that. And you've laid out the guidelines. It needs to be this way. It must be original material. I don't want it, reused 2 and 3 times on several different platforms. And that'll help protect you from them coming back and saying, well, you copied that off of our website. Earl didn't give that to you. So you have processes in place as well. So, yeah.
And I'll go so far as to say that at least one of your articles is republished in my magazine in its original format, but there's a note on the page or on the website that says reprinted with permission, because I asked you, can I take this in whole? But even if I just copy and paste, if I wanted to use a paragraph of it to highlight something that I'm doing, I would just call you up and ask, can I do this? And maybe get an okay in written form, right, Doug? As long as I can prove that Earl gave me permission to use this, I'm good to go.
You know, Nana, we'll take and just juxtapose that for 1 second, because a lot of people think that, hey, if I saw Earl's work and I put it on my website and I put Earl's name below it, I've attributed and that's okay. That is not, because that is still copyright infringement. Your situation, Anna, to where you worked with Earl, you got it in writing, in an email, in a letter, however it was that Earl said, yes, you may use this. That's the perfect way to do it. But trying to take it from somebody else, I know Anna's all, woo! But, and you should be, because if you do it the other way and you just take Earl's stuff and put it on your website and say, hey, this Earl created this, here we are, you know, this is Gregorich's stuff. What that does is it makes my job easier, because you just admitted to copyright infringement and you were saying it was Earl's where it came from. And there's no really Scooby-Doo mystery here. You took your stuff from Earl without his permission.
Right.
But the way that you do it to where you get permission in writing, because memories are fallible, definitely get an email, get writing, get a letter, do something that says, I have permission to put this, whether it's a website, whether it's a print copy. Remember, copyright infringement is a broad tentacled beast that goes into a lot of different formats.
I could talk about this stuff all day long because of the business that I'm in. There's so much to it, but we're going to cut it off here. I'm sure that we'll be taking pieces of this conversation, like I said, into the insurance realm and different areas. We'll bring in other professionals to talk about different aspects of it. But in the meantime, thank you very much, gentlemen, and I will meet you at the next conversation.